and all. I am very delighted to introduce our guest and speaker for today's RG Townhall guest lecture series, Mr. Bharadwaj Jaishankar, sir. Mr. Jaishankar is a partner and co-leads the intellectual property practice at IndusLaw. He has over 13 years of enriching experience in the field of IP, which involves protection, enforcement, and commercialization of IP assets. His work experience involves working with some of India's leading tier 1 intellectual property boutique law firms. He has also worked as an IP and Innovation Counsel for one of the world's leading FMCG organizations responsible for IP and innovation legal issues for the Asia Pacific region. He has also been actively involved in some precedent-setting judgments passed by various courts in India and has advised diverse range of clients on various aspects of IP rights as well as related areas, that is information technology, contract law, and general commercial laws. His practice involves conducting IP due diligence, audits, as well as advising on IP structuring in corporate and commercial transactions. Mr. Jaishankar is a visiting faculty at leading law universities in India and is currently an active member of International Trademark Association, INTA. We extend a warm welcome to you, sir. Before we begin, I would take the privilege to introduce you to RGSOIPL, that is Rajiv Gandhi School of Intellectual Property. It is one of its kind law school to impart legal education with IP specialization within IIT system and is ranked 4th among law schools in India by NIRF ranking 2001. Moving on to today's topic, that is how to build brand identity through IP. We request you to kindly take over, sir. And also we request the audience to kindly keep the mic mute. And if and when you have any doubts, you can raise hands and put your unmute and put your queries across. Handing over to you, sir. Thank you.
Thanks, Shreya. Thanks everyone for having me here. And before we start, wish everyone a slightly belated Diwali. I hope everyone had fun with their family and got to celebrate Diwali in what continues to be challenging times for all of us. I wish I could do this in person with all of you, but in COVID circumstances, still happy that we can do this over a call. So look, thanks for having me. Thanks for the introduction. So like Shreya said, if at any time anyone has any questions, please feel free to raise the hand, ask me, drop it in the chat. Let's make this as interactive as possible. I've not really come with any deck as such, but rather have some speaking notes. So if you see me turn towards the side, I have my speaking notes to the left of my monitor. So, okay, so with that, let's get started. So, a couple of things I'm extremely passionate about. One is interacting with learners, IP enthusiasts, because you guys are the next generation of IP lawyers. And I certainly have some very, very good friends from IIT Kharagpur, from your School of Law, some very celebrated alumni who are very dear friends of mine. So, so I love interacting with students. The second thing is I'm very passionate about brand building because I've been an IP counsel for over 13 odd years. I've been an in-house counsel developing brands from within a company, which has a different perspective altogether. So this is a topic that's quite close to my heart. So thank you so much for that. So, why is, compared to what it was, let's say 10 years, 15 years back, brand building today is everything, right? Especially if you're a startup looking for funding, or you've got funding and you're looking to take your brand to the next level. We're talking about a highly competitive market, a highly competitive world, right? Where you're seeing such innovative businesses, such cutting edge technology coming out, and you're really competing for space. And, it becomes that much more important to really have your brand stick out. And by brand, I am sort of including within it trademark, patent, design. software codes, your IP gamut itself, right? So let's sort of equate the word brand building to IP building in that sense. Today, including me, we are very fickle-minded as customers. We look for good deals, we look for good products. Most of us are quite brand conscious, right? Because certain brands have a certain standing because of, let's say, the marketing campaigns they have or the technology that they employ. There is a reason why people still, are crazy about Apple products, right? It's not just about the Apple brand or how the phone looks or how the iPad looks or how the new AirPods look, but it's about the entire technology behind it. It's about being able to walk around with an iPhone 13, right? And that's a really brand building that we're talking about. You must forgive me. I've worked in the liquor industry for 3 years as an in-house counsel. So, when you work with brands like, let's say, Johnny Walker or Smirnoff, and you go to a restaurant and you order yourself a Johnny Walker, you know what you're going to get. And there's a reason why you want to go after Johnny Walker, right? And let's say not an Indian whiskey, for example. So your customer tastes is so dynamic. It's constantly changing, constantly evolving. And if you couple that with the whole Make in India drive that's been going on for a couple of years now, there's definitely a huge um, weightage that is given to the way a product or a service is packaged to the customer. So that becomes important. In some sectors like food, for example, you know, what was earlier a very Western concept of gluten-free, vegan, organic is now part of mainstream Indian food, right? You go to any market, you go to a big basket or you go to a Dunzo and you order, the amount of, let's say, health products that you see, sometimes it's easy to get confused, and you sort of tend towards the one that has a flashy packaging, that has nice descriptions, or when you Google, you read about certain brands. So it's really important as um, a brand house to market yourself and to be aware of shifting trends in the sand. The other highly influential factor in brand building, which I have noticed, is the advent and impact of technology. I mean, we can't ignore the elephant in the room, right? Uh, every day that we wake up, we're surrounded by technology that influences us. Um, right from the smartphone that we buy to the laptop that we use to the gaming mouse pad that one has, right? It has a huge influence, technology. So that's something that, when I work with startups, when I work with mid-sized companies, work with Fortune 500 companies, there's an innate sense to promote the technology as the brand, right? That this is why, because of this technology, we are set apart from our competitors, right? So if you look at, for example, Dunzo and Grofers, the ability to now deliver grocery items in under 30 minutes is being promoted because of their technology, being able to connect your kirana stores, your mom and pop stores close to your geolocation, that they're able to pick up a loaf of bread and deliver it to you in 20 minutes without you having to leave the comfort of your home or your hostel or wherever you are. So the influence of technology is massive, right? The other thing that's increasingly happening is that influences brand building is um, the purchase power of customers, right? Today more than ever, at least with the last 2, 3 generations, we like to spend on good things, right? I mean, traditionally we've been conservative in terms of how we spend and what we have to spend on. But now, when you go out with your friends, you want to go to a good restaurant, you want to go to a good bar, you want to buy good branded clothes for Diwali, right? And you're willing to spend for it. You're willing to upgrade your tech every 2 years. Certainly, I like to do that because of purchasing power. And therefore, if as a brand you're able to tap into that purchasing power, especially with the younger generations, right? And you marry that with, with promoting your tech, for example, I mean, you have a winning formula there in terms of brand building. Um, the other influencing factor, and this is before we get into some of the IP issues, just sort of, a lot of what I'm saying you probably know about already. The other big thing that we are seeing is a link between brand building and social causes. We're increasingly becoming a lot more conscious about the environment, about, giving back to the community. And that plays a huge role as well, because you don't just want to be a good brand, but you want to be a responsible brand as well, right? If you look at, for example, the entire ocean cleanup effort, I was watching a YouTube video the other day, collecting the plastic from the Pacific Ocean and converting it into sunglasses, and it being marketed as, sunglasses made from plastic picked up in the Pacific Ocean. It resonates with consumers, right? Especially the younger audience who are extremely socially conscious. And if you look at the larger issues of what's happening around the world with racism, extremism, the connect between a brand and the grassroots community is so important. And even investors, they give a huge weightage to what founders are willing to do back for the community, because it speaks about the ethos of a brand. So I found these 4-5 factors heavily influencing brand houses in deciding which way to set up their innovation and marketing plans. Also because I've had to consider this in my past life as an in-house counsel. Okay, so look, from an IP perspective, what are some of the real key issues that you need to keep in mind as you're building a brand? And I'm also conscious that many of you may want to embark on your own entrepreneurial journey, right? Or you may end up joining a funded startup that's different stages of their product development. And the one thing that I've noticed is the consciousness and the importance being given to IP as a backbone of a company is definitely increasing. Okay, in the sense that earlier IP used to be seen as not so important, we'll worry about it if an issue comes up. But with investors, being quite strict, quite conscious about IP protection being given by the founders, by a company to their IP, whether it's registered or unregistered, that's really on the increase. So whenever you guys start your career, start working with companies or even as in-house counsels, please do not underestimate the role that IP plays in brand value, in brand equity, and in really building a brand. There's a reason why Pepsi and Coke continue to be trailblazers. And I'm not sure if many of you have heard of Gold Spot, which was big in my time. But the brand fell apart. Another good example is Xerox. Xerox is actually a trademark, right? But because Xerox Corporation did not have sufficient mechanisms in place to protect the generous side of the Xerox brand, Xerox became a common word. You would go to any photocopy shop and you wouldn't say कि भैया मेरे को 10 photocopy चाहिए, भैया मेरे को 10 Xerox चाहिए, right? So that's a classic example of a brand which was very well known, and companies didn't really give enough importance to brand building. And now Xerox Corporation are scrambling to try and build brand equity around the word Xerox, and they're up against it. So the first and foremost step in brand building is ideating the brand, right? Now, whether you're ideating the brand name, or you're working on the technology, or you're working on, let's say, the first draft of a screenplay or of a song, the ideation becomes really important, right? You want to pick a trademark that's distinctive, that actually does not describe the product. So marketing principles tell you that the closer the link between the brand name and the product, the better the recall factor for a customer. From an IP perspective, it's the exact opposite, right? Bigger the gap, higher the recall factor, right? So it's important that when you're really conceiving your brand, you sort of identify what's the messaging you want to get across to your investors and end consumers. At the conception stage, you involve your IP lawyers, whether it's in-house, external counsels, and you talk to them not just about filing applications, because that's the easy part to do, but really looking at ways to grow the brand. So there might be many IPs as part of the brand that you can't register. So for example, let's say that you're developing a unique software. Software per se is not patentable in India, right? There are some restrictions. So really sort of understanding with your counsel, what is the best way I can protect my source code, right? Because as part of the source code, as part of the package, you have confidential information that comes, you have trade secrets that come as well, right? And data, protecting your data, right? So in the absence of a sui generis legislation for trade secrets, for confidential information, you end up protecting it through contract, right? NDAs, for example, confidentiality clauses. So really at the ideation stage itself, you start thinking about all of this, because the last thing you want to do is to do the ideation, commit time, money, and resources, only to find that you've not done your housekeeping properly, right? So that becomes important. I'm dealing with cases right now where clients have invested a lot of money into developing a brand. We ran clearance searches and we found that there are identical marks already existing. And the founders did not have the visibility, did not have the knowledge or had the contact to reach out to an IP counsel to say, hey, you know what, can you run a quick search? And before you know it, as a founder, you're burning through money given by your parents or by a friend or by an acquaintance without having done your housekeeping. So, ideating your brand becomes so important. Part of this is also sort of having a rough idea about, do you want to operate within India? Do you want to operate in the Indian subcontinent? Do you want to go Asia only, or do you want to go to the entire world? Or let's say if you're a software company, do you want to end up starting your operations in the US, for example, filing an application, a patent application in the US through the PCT model, and then after 31 months entering India, right? These are all conversations that you need to have at the get-go, not necessarily have everything set in stone. I mean, if you have it set in stone, then perfect, right? Then that gives you an amazing launch pad. But you need to be having these sort of conversations and having these discussions with potential investors, with your business gurus, with your lawyers, for example. Right? It becomes really important. The other bit that you need to consider is the fact that because of COVID, almost everyone has gone digital, right? Almost every business has gone into an e-commerce model, right? Uh, you know, till maybe a couple of years back, most of your, premium brands, premium to luxury brands. Let's say if you look at Aldo shoes, or if you look at Clark's shoes, for example, you would normally buy these shoes either from a mall, or you would buy them from Myntra or from an Amazon, right? None of these brands really had an India-specific website that had an e-commerce model, right? But COVID's changed all of that, right? So that's another factor to consider when you're ideating your brand. What is the business model that you want to operate? Part of this is also looking at, do you want to operate a B2B model? Do you want to operate a B2C model? Do you want to operate a D2C model? So it's all of these factors that you sort of have to keep in mind when you're ideating. The next step that comes with ideation is, what are those key brand assets that are core to your business? So from a trademark perspective, you would look at what is the word mark, what is the logo that you have in mind. Do you want to have a composite mark, which is a logo plus words? Do you want to have a tagline, for example? These become some brand assets, right? And your logo sort of also acts as an artistic work under the Copyright Act. If, let's say, you're only into software, for example, and you're essentially a back-end integration software, where trademark might not be as important as, let's say, protecting your trade secret or your source code, or possibly even a patent application. It then becomes important to identify what is that core source code and what's the best way to protect it. It's increasingly common for companies to protect their source code as a literary work under the Copyright Act. Right now, you don't have to disclose your entire source code because no one would want to disclose the entire source code, right? But there are ways to protect the disclosure of the entire source code with the Copyright Office. But at the same time, you're identifying that source code as your brand asset, because it's those assets that's going to generate visibility to the customers, that's going to generate hits on social media accounts, that's ultimately going to rake in the money for the company. So protecting your brand assets becomes really important. And once you've sort of done this ideation and you've identified your brand assets, what's the next logical step? It's to file applications to protect the IP, or entering into contracts to ensure that trade secrets, confidential information is protected. If you have an invention, if you have an improvement to an existing product that you think is patentable, has tremendous commercial scope, you would want to ensure that anyone you talk to about it is subject to an NDA, right? Because the moment you talk about it to someone else and you're not subjecting them to an NDA, you're hit by prior art. And suddenly the entire value that that particular invention or improvement had goes out of the window, right? That's where you really sort of bring in the lawyers and talk to them and say, hey, this is what I want to do. What are the different ways I can protect it? So it then becomes important to look at both registrable and unregistrable mechanisms to sort of protect the IP. Because what we are talking about now is laying the foundation for brand building, right? Your marketing and all we'll come to in a bit, but this is all your foundational steps, right? So I'm going to pause here. Anyone has any questions? And there are no stupid questions.
Question, what is the difference between brand value and brand equity?
Okay, great question. Not too much of a difference. Okay, it's common parlance that's sort of used. Usually when you're talking about IP valuation, you use the word brand equity, right? But they are fairly interchangeable terms. So yeah, I don't think both of them have a strict legal definition unless one of you can, tell me to the contrary. But in my understanding, they're essentially the same thing, Utsav.
Okay, thank you.
Perfect. So if no other question, I'll sort of move. Yeah, Tushar, I saw you raise your hand.
Yes, sir. Good afternoon, sir.
Good afternoon.
Sir, I want to know that can you just elaborate on what is this brand management and brand building? Is there any difference in brand management and brand building?
Okay. So normally when you talk about brand management from an IP perspective, Tushar, you're generally talking about ways to docket and manage your IP. Okay. So let's say if you're Coca-Cola and you have 300 trademark applications in India, you have 10 patent applications for the manufacturing and bottling process, and you have, I don't know, let's say 100 trade secrets. How you go about managing all of this IP is brand management, right? So from a pure IP perspective, one vertical is docketing softwares that you have, which records all of your IP. The other management is just keeping an eye on, let's say, when you're talking about agreements for unregistered IP. How are you managing the IP clauses? Is there a license in, license out? If there is a sub-licensing arrangement, for example, how is that being managed, right? Brand management falls within the ambit of brand building, right? A huge part of building your brand is also knowing how to manage your brand, right? So protection is one part, managing is the other part. Have I answered your question, Tushar?
Yes, sir. Yes, sir. Thank you.
Perfect.
I too have a question.
Sure.
So, like, for now that you mentioned about companies thereof suffer from January side, so I would like to know that how does the company assess the risk or navigate around it even before it launches its product, and like should the company go about it about accessing and navigating the risk that if the company would be suffering from January side?
Okay, great question, Shreya. There is no obvious answer, right? Because you have to go by facts and situations for each case in that sense. But broadly, what you want to do is, as a company, as an in-house lawyer, for example, right? You need to assess first what is the commercial objective. Now, if the commercial objective is I'm going to launch this brand no matter what the risk is, then you find ways of mitigating that risk, right? Because ultimately, as an in-house counsel, or let's say even as an external IP advisor, the guys who really call the shots are the people who make money for the company, which is your sales team and your marketing team. Essentially, who we are as lawyers are business partners, right? Now, unlike tax, for example, where you can clearly determine when and where tax liability comes up, with IP, it's very gray. Like what I might think is high risk, you might think it's medium risk. So it goes from perception to perception, right? And that's the beauty and challenge of IP in that sense. So I would say, my experience, I start off by understanding what is it that the business wants. Then you call out the IP risks, including sort of projecting, God forbid, worst case scenario, what are likely damages that court might impose. Because that's always a worst case scenario, right? And then you let the business guide you on, look, we don't care, we are going with this approach, we are willing to accept the risk. Then you get into a mindset of what do I do to mitigate the risk, right? So let's say if it's from a trademark perspective, can I add other elements to my mark? Instead of using a word mark, can I use the logo, right? If it's, let's say, a song that you're writing, right? Can I somewhere employ the de minimis principle to set my song apart from someone else to prevent copying or to not copy for that matter? If you're talking about a design, can I add certain aesthetic adjustments to the design of the product that sets it apart from a competitor? So you find ways to mitigate the risk. And you then go in probably not gung-ho, but you sort of slowly increase the ante, right? So it's a bit of, you're grabbing the market silently. So there are different brand building strategies in that sense. Now, if your commercial teams are clear that, you know what, the risk is too high, we are willing to pivot, look at another brand, then it makes your job a lot easier as a lawyer, right? So in terms of how you go about assessing a risk and what brand building strategy to adopt, you really have to first understand the commercial interest behind it. Very, very important to not take a legal approach, but instead fit the commercial objectives into the four bounds of the law. So I'm conscious here that I've probably not given you a very specific answer, but it really differs from circumstance to circumstance.
Thank you so much, sir.
Sir, so
Yeah, go ahead.
essentially from what you are saying, there
Hmm.
is with the developments in the digital media and so on and so forth, there is a huge chance of legal liabilities exceeding uh, um, exceeding and increasing enormously. So
Yeah.
how do brand owners actually take advantage of these certain developments to enhance the legal protections for these brands?
Okay. So, okay. Thanks, Aishwarya, for that. So, look, when it comes to the digital space, you have to be slightly conscious about which platform you're going through, right? Now, if you look at your social networking websites, all of them have their own takedown, stay down procedures. All of them have their own IP guidelines on what you can do, what you can't do. Even if you look at your simple AdWord program run by Google, there are guidelines on trademark use, for example. So in terms of really assessing liability, it starts off by understanding what is the platform that you're really engaging with. It could even be, Aishwarya, as simple as if you're using open source software to develop tech, you need to understand what are the terms and conditions of that open source database, right? Similarly, when you go to Getty Images and try to take an image that you want to use as part of, let's say, a marketing campaign, you have your watermark at the bottom that says Getty. But many people don't understand that even if you can download the image, there are still terms and conditions on what you can do, what you can't do with what is essentially a licensed IP, right? So from a liability perspective, it's first understanding what are the terms and conditions of the digital space that you're operating in. The second bit is sort of if you're entering into contracts, if to try and put a cap on liability. Right now, if you're a licensor of technology, you wouldn't really want to put a cap on liability, right? Because potentially, if the licensee is in breach of licensing terms, the damage could be a lot more than what is stipulated in the contract, right? And it's increasingly common to have separate IP liabilities versus non-IP liabilities in contracts. Similarly, having separate IP indemnity clauses compared to other normal indemnity clauses in contracts. Likewise, reps and warranties for IP separately. So when you're talking about liability, Aishwarya, you need to consider all of these factors, right? And unfortunately, we don't have too much of guidance from courts in India in terms of damages because it really varies on the quantum of infringement. But broadly, I would say these are things that you do have to keep in mind on liability. The other important bit on liability is to keep in mind the fact that majority of IP disputes now are being referred to arbitration, right? Because now IP disputes are arbitrable. There are enough judgments to that point. So therefore, addressing liability issues becomes a lot more faster in an arbitration. And therefore, it's important that the groundwork that you do to understand liability issues becomes equally important as well. So again, Aishwarya, I must apologize. I've given you a very general answer, but it really depends upon, that particular set of circumstances and the situation that we're talking about. What is the IP that we're talking about? What is the associated brand value of the IP that's being involved, right? So as an in-house counsel, when I was, we were a giant in the industry. And when we would enter into contracts with smaller parties, then invariably we're willing to relent on liability a little bit, provided the reputation of the brand is secured. Because we're also conscious that if I impose a liability cap of $10 million on a startup, there's no way he's going to be able to pay $10 million if there's a breach, right? You then look at ways to ensure that the reputation around your IP is secured. So that's another factor you consider when sort of looking at liability issues. Have I answered your question, Aishwarya? Have I given you some insight?
Yes, sir, absolutely. Thank you so much.
Thank you. If you guys think I'm not answering your questions, please let me know, okay? Cool. So we've spoken a bit on the foundation of brand building, right? Let's sort of look at the next stage, which is we've laid the foundation. we filed applications or we entered into contracts to protect our IP. We then have a conversation with the marketing team, whether it's digital marketing, brick and mortar marketing, to find out what's the best way I can get my brand out to the market. Right. Now, obviously, that's heavily influenced by how big your marketing budget is. It also depends on the sector that you're operating in. So, for example, in the pharma sector and the alcohol sector, very strict guidelines on what you can market, how you can market, right? Even for example, I think it was Flipkart that came out with a series of advertisements with children as a part of the advertisement. Very strict guidelines from the government on, what you can do in an advertisement when children are there as actors in the advertisement. So those are factors from a regulatory perspective you need to have sorted out. If you look at the FMCG sector in India, many times you have a lot of disparagement that happens, a lot of comparative advertising that happens, especially with home essential products, right? Where one brand tries to say that, I am better than him. FYI, his product is also bad. Now, it's okay for me to say I'm best in the market, but I can't say he is bad, right? That's the basic law. So sort of understanding all of these marketing principles as well before you jump in with the actual launch, because with the launch, you're going to be doing a lot of shosha around the brand launch, right? Yeah, Samrat, I saw your hand up.
Thanks a lot. Sir, it is very informative, this particular session, but I'd like to actually take forward what Shreya was trying to take, positing that question. I'd like to bifurcate my question into two parts, basically, if you can address both of them.
Sure.
One is that you did mention about the fact that there are arbitration clauses which are potentially also helping companies to address their IP issues. But I want to also understand that when there are particular occasions, for example, unforeseeable instances, or for that matter, force majeure clause, and so many clauses which are actually open-ended, and there are also issues which are actually beyond the indemnity clauses and all. So how to address that one from an IP perspective? And my second question to you is that specifically, sir, if you can actually talk about, like, when you talk about what Shreya was also trying to posit that question is that when we try to take it forward, that the interaction of IP companies, what is the interaction do you foresee with the government? Specifically, what are the expectations do you have from the government's perspective? Like, actually, I'm so glad that you actually addressed those questions, sir, and so fortunate to hear you. But I'd like to try to understand the broader contours of what the canvas of your interaction IP companies, the role of an IP manager, or for that matter, IP brand manager, in that context of interaction with the government, and what kind of issues do you come across, and what are the expectations from the government that you have from, and I'll be so glad if you can answer these two questions.
Fantastic. Thanks, Samrat. So, okay, so we'll just slightly pivot from the conversation and answer these two questions. So before I answer, fantastic questions, okay? So please keep these questions coming, because what you're asking are questions that you will end up facing as an in-house lawyer or as an external counsel, or as entrepreneurs as well, right? So fantastic, keep it coming. So on the first question, Samrat, it's really interesting because prior to COVID, the issue of government-imposed lockdowns or pandemics never formed part of a force majeure clause, right? And suddenly when COVID hit and we had the first lockdown, I remember scrambling through all of my contracts with my vendors to try and somehow see if there was something in the force majeure clause that would prevent the vendor from not fulfilling their obligations under the contract, or if there was something in the force majeure clause that I could take benefit of to sort of, if I'm unable to fulfill a certain obligation under the contract, right? So it really depends, Samrat, on what is that unforeseeable circumstance that's come up as far as force majeure is concerned. So you really want to keep your force majeure clause as broad as possible. And it's now very common to have government imposed lockdowns or curfews as a part of force majeure clauses. The on the bit about indemnity, again, it comes down to your skill as in drafting the IP indemnity clause. So as far as possible, depending upon whether you're a licensor or a licensee or an assigner or an assignee, you want to ensure that your reps and warranties against which indemnity is given is foolproof. Right now, if you're, let's say, a licensee, you obviously want the licensor to rep and warrant that the IP that's being licensed is free from any third-party claim or encumbrance, right? And you will then have an IP indemnity that's linked to this rep and warranty. Now, if due to poor draftsmanship, the rep is not there or warranty is not there, it becomes difficult, and your indemnity clause is also weak. It becomes difficult to argue for indemnification by the licensor, right? So you really have to understand what is the IP that's being licensed, what is the licensed IP or the tech transfer, for example, going to be used for, and then you sort of work the reps and warranties and indemnity. I'll give you a great example I'm working on right now. I obviously can't name the clients, but if you have a situation where someone has applied for the patent application, it's not really a patent license, it's a technology license, right? Because the patent is still pending. You would therefore want to have a rep and warranty on the patent application, it being prosecuted by the licensor. And you would want to have an IP indemnity that if the patent application is refused and you as the licensee suffer damage as a result of the refusal, which could also be suddenly third parties jumping into the market because the technology is no longer privy only to the licensor because the patent application is refused and you suffer because of that. You want to ensure that your indemnity clause captures this, right? So it really begins from understanding the construct of the contract itself, which goes back to my earlier point, understanding the commercial objectives before applying the law, right? So Samrat, have I answered your first question to some extent?
Yes, I think substantially, sir. I want to thank you for that one. But I'd like to actually hear from you very interestingly the second
Sure.
bit of,
So great. It's always a fairly tense, comfortable relationship that the government and IP and brand houses have, right? So if you look at, for example, there is a lot of noise being made between the government / regulators with, let's say, e-commerce giants in India, right? Brand owners whose products are sold on e-com platforms also have issues because of counterfeit goods being sold. In situations like this, you know that as a brand owner, you and the government are sort of on the same side, and therefore it's easy to argue and push through policy or changes in law, which rarely happens. But when you're really engaging with the government, you really need to be careful because if you're, let's say, an external counsel, right? If you're an IP lawyer working in a firm, having your own firm, and you're working with the IP offices in India, or you're working with the Ministry of Commerce to influence policy, you don't want to take too aggressive a stand that pushes the government off, but at the same time, you want to ensure that some key issues are identified. So I'll give you guys a very simple example, right? So last month, the newly created IP division of the Delhi High Court had issued the draft IPD rules for stakeholders to comment on, right? And there were some lacunae in it that we pushed back on as practicing lawyers to say that, look, the draft rules are great. Fantastic step to, replace the IPAB with a special IP division in the High Court. But there are some key lacunae A, B, C, D, E. So you sort of couch it in what you see as a threat to the brand, to brand building exercises, and then you sort of engage in a dialogue. What you don't want to be doing, Samrat, is you don't want to be bad-mouthing the government, bad-mouthing regulators in public forums. So you need to be really tactful about how you go about engaging with regulators. Right? It's as simple as if I'm arguing for the acceptance of a trademark application with an examiner, who at the end of the day is a public employee, right? He's employed by the ministry. I have to ensure that my client's interest is protected. I have to ensure that the firm's reputation is maintained. So I can't be overly aggressive. Different examiners have different standards, right? I can't go tell an examiner that, you know what, you have no common sense at all. You're an absolute idiot. Now, I can't obviously say that, right? Because I have my client's reputation at stake. I have my own reputation and firm's reputation. Plus, you don't want to really badmouth a public official. So, Samrat, in that sense, you have to be really careful as lawyers to not let your ego and emotion take the better of you. Right? You need to keep the focus, the sole focus only on the conversation that you're having with the government official. And play it tactfully, especially if you're in a company. Sorry, just one last one. If you're in a company, and you're a fairly large company, let's say Facebook, for example. Facebook has a separate IP team. They have a separate government relations team. They have a separate policy team, right? So you need to be working with all of these teams to project the right position forward to the government. Part of this is actually conducting training sessions with government officials, which many brand owners do, whether under the umbrella of CII or FICCI or their own brand building. So in Diageo, we used to run trainings with customs officials, police, to sort of help them detect what is a counterfeit Johnny Walker and what's a genuine Johnny Walker. So when you engage in these conversations with the government officials, they also feel supported by you. So it's important to maintain that sort of a balance, Samrat.
Great, wonderful. Sir, would you also like to also touch upon the point that post this another bench which has been created in the High Court of Delhi, like for because IP appellate tribunal is no more now. So how do you see it in ground reality? How is it that how the IP managers are actually seeing it in reality? Like, do you feel that it's more receptive to the points, or is it that it's more formalistic in its approach?
So Samrat, I will very briefly answer this question because I'm conscious that we're slightly deviating from the topic, and I'm also conscious that we're coming up to 4 o'clock. I will say that all of us are waiting and watching to see what happens, because it's only the Delhi High Court that's already moved forward. Not any of the other high courts at the moment. So we are doing what we can instead of filing an appeal to file a review instead, for example, to buy time to see what happens. Some lawyers have already filed miscellaneous applications in court to challenge orders which would otherwise be filed with the IPAB. So it's a bit of a mix and match and waiting and watching. So Samrat, if there's a further questions on this, you can take my email ID from Shreya. You can drop me an email and we can have a separate conversation on this.
Thanks.
Does that work for you?
Fantastic. In fact, it's such a pleasure to have you today. Thanks.
Super. Okay, so we were talking about marketing, right? So you need to ensure that your marketing messaging that goes across for brand building is in sync with the brand message. You can't have conflicting messages going out to the marketing on your marketing comms, which then therefore raises an interesting question, because almost everyone wants to promote their brand through Insta or Facebook or Twitter. What about hashtags, right? Can you really claim proprietary rights over a hashtag? Right. And that's an interesting question, because there have been instances where companies have received legal notices because someone claimed ownership in a hashtag. Therefore, due diligence before marketing becomes important. When you're engaging an endorser, a celebrity, to promote your product, having a watertight agreement with the celebrity, including having a morality clause from both sides, becomes important for brand building. In light of the recent amendments to the Consumer Protection Act, you do not want a celebrity who has not done their due diligence on your product, which then therefore raises liability on both sides. You don't want to engage a celebrity who is in the midst of a controversy, which then therefore has a direct say on your brand reputation and your brand standing. Why would a consumer want to buy a product which is endorsed by someone who's in the midst of, let's say, a financial controversy? Because then you directly question, what does the company really stand for, right? And there have been enough instances of endorsers being let go because they were in breach of a morality clause. And there have been cases where endorsers have walked away because the company has been in breach of a morality clause. And that feeds into your brand building, right? Because when it comes to marketing your brand that you've really worked your socks off to protect and lay the foundation, then that's where the reputation and optics issue becomes important. So that's something that you really need to keep in mind. Now, related to this is also, how do you go about enforcing your rights as a brand owner? You can't obviously go after each and everybody in a country like India because you have, infringement, whether it's counterfeiting, piracy, or a lookalike, happening across India. You never know, right? Someone sitting in the northeast of India could be infringing my right and I have no visibility over it. Or someone is doing it, but small party. Do I really want to spend my time, money, and resources going after someone who's not really affecting my bottom line at all? Optics. Do I want a David versus Goliath situation? What happens if I send a small party a legal notice? He puts it up on social media and says, I've received a legal notice from big bad company trying to bully small family business. And then you put hashtag uncompetitive, hashtag bully, hashtag this, hashtag that. What happens to all your brand building? It takes a hit. Suddenly your investors are calling saying, what is the strategy that you're adopting? Are you trying to be bull in a China shop and go after everyone? Or is there some cogent thinking that you're employing, right? So it then raises another allied issue. Do I really need to engage lawyers? Can I business to business talk it out? Have the head of marketing speak to a small-time infringer. Say, you know what? You may not be aware of IP rights or the fact that we own rights. Here is the infringement. You take that soft approach, 8 times out of 10, the issue is sorted out. If you go in with a lawyer, you go in with a battery of lawyers, the other side is going to say, you know what? I'm being bullied. And, social media is there for everyone to say anything that they want, right? So your enforcement is as important as brand building. When we spoke about Xerox, you want to have an enforcement strategy that does not dilute or whittle away all of the brand building that you have done, right? At the same time, you don't want to commit all of the company's resources into an enforcement strategy that's never really going to give you the sort of damages that you want to set off the cost of enforcement. So for example, if you look at BSA, Business Software Alliance, or Microsoft's anti-piracy campaign, which was really active till a few years back, it was one of the few IP enforcement programs that funded itself, right? So that again influences your brand building, because the more money you save on enforcement or engaging external lawyers, the more money you have, the more resources you have to commit to brand building, right? The last point on brand building, and I'm conscious we have 5 minutes left, is now that you've got your marketing, you've got an enforcement strategy, how do you expand? One great way is to do what Baiju does. You just outrightly buy your competitors, right? You do what Make My Trip did as well, and they bought their competitor as well, right? Or you start acquiring smaller companies to increase your offerings. So your bouquet becomes larger. So, or you find ways where you sell your brand to someone else, but you take a position in the purchaser's company, right? And the brand continues to be alive. So having that sort of a conversation with your investor, having a long-term strategy on what you want to do, because most startups want to enter the unicorn club, right? And I think this year we've had about 31 or 32 or new companies into the unicorn club. And that's the dream for anyone who's starting their own business, right? So having that sort of a commercial objective, how do I get to the unicorn club? How do I break the $1 billion valuation? How do I get an IPO, right? That's where you start looking at commercial acquisitions, commercial tie-ups. So that's also part of brand building. So I'm going to pause here and give the last 5 minutes for questions. If we don't have time, you're more than welcome to send me an email and I will respond to any questions sent by email as well. But yeah, I'll throw it open to any questions now. Any further questions? Yes, Aishwarya, go ahead.
Yeah, hi sir. Thank you so much for being here today, first of all. And well, from a layman's perspective, this is just a question about from the technological field. Could you please help me know as to which are some of the areas in the intellectual property law field which is constantly facing the challenges because of technological advancements?
So straight, your two biggest ones are copyright and patents. Right? Those are the two that's heavily influenced by the evolution of tech, the interaction between IP law and IT acts, for example, right? So your 2021 intermediary guidelines, how they influence copyright, for example, huge issue. Is your technology patentable? Is also a big issue. Another big issue is if you have a product, right? Not a service, if you have a product, what are the ways I can protect the product? There's a trademark angle. Can I protect it as a design, for example? So I would say that copyright and patent are number one in terms of being influenced by the evolution of technology, simply because our laws are way off pace, right? Followed by designs. Trademark is probably at the end. It's not really that much influenced by technology because it's just the front-facing brand. But if you do want to sort of build a career in IP, then definitely look at copyright and patent. It's a hot space, right? Especially when you look at NFTs, which have come up in the last couple of years. If you look at, the prominence being given to IoT, ML, AI, that's the space you want to be as an IP lawyer. So, if you're looking at it from a career pathway, start looking there. Nothing wrong with trademark, but that has more scope to grow. Yes, there's one more hand raised. Garima, go ahead.
Yes, sir. So I wanted to ask about how the contract negotiation actually works. Because as a startup, we are getting funds from the funder. So when it comes to retaining our IP or the liability clauses or the indemnity clauses for that matter, how the startup makes sure that during the negotiation, the IP remains with us, because that's one of the very important asset for building a brand.
So, Garima, the best way to start a conversation on protecting your IP as a startup is actually to ensure that as the founder or as your startup company, you've actually taken steps to protect the IP. The moment you've done that, you're automatically in a solid position, right? Because so for example, if the IP is in the name of the founder, not in the name of the company, investor gets a little antsy because they want the IP to be assigned to the company. What if the founder leaves tomorrow, right? So you want to ensure, Garima, that before getting into any conversation with any investor on IP, on contracts, your housekeeping is sorted first. So some of the stuff that we spoke about at the top of the session today, you want to ensure that all of that, your ducks are in line before you speak to an investor or get into contract negotiation. The other tip about contract negotiation is beforehand, it's good to know what you're willing to give up and what you want to retain. What are your walkaway clauses, for example? Right. These are a couple of things that, as founders from an IP perspective, very important.
Thank you so much, sir.
Sorry, Shreya, I'm conscious we have one more minute. Can we take one more question?
Yes, I think Matthews is trying to ask something for very long now.
Good afternoon, sir. This is Pooja Pal. I want to ask one question.
Sure.
Sir, like brand identity plays an important role in the market. So, what are the challenges most customers face while building a brand identity in the market?
The challenges the customer faces with brand building.
Yeah.
one of the biggest challenges is probably understanding what's a fake product and what's a genuine product. How many of you face an issue that when you order from Myntra, you get something in a translucent plastic
Like
pack?
if we starting the like zero on this from the zero, like from the startup. So what are the most likely challenges that we have to face?
Well, your biggest challenge is ensuring you adopt the right brand and the right brand asset. And we spoke about the foundation, right? Once you get the foundation sorted out, and part of the foundation also involves market data, customer data, market research, you're on your way. If your house is not in order, Pooja, then you're in trouble. You can face risks from anything from counterfeit to your positioning getting diluted to uh, brand value just disappearing. So it really depends on the effort that goes in at the ideation stage. Sorry, Shreya, let's do one last question. I think you were saying that Matthew had a question, and
Yes,
then we can sort of
Matthew,
close out after that.
Yes,
sure,
Sorry,
sir.
Pooja, have I answered your question to some extent?
Yes, sir. Yes, sir. Thank you, sir.
Fantastic. Yeah, Matthew, go ahead.
sir. From the discussion that we had, the idea that I get is we need to have a multi-dimensional, like we need to be jacks of all trades to like manage a brand. So how do we develop that? Like we need to know a bit of marketing, like a lot of IP.
Well, Matthew, you need to understand IP law. Okay. You don't really need to understand marketing principles too much. You need to understand IP law, and you need to understand what the business wants. The moment you have a basic understanding of trademark law, for example, what is a good trademark? Or you understand Section 9, Section 11, for example. You understand the import of Section 27 and 29, for example. And you marry that with what the business wants, you're already in a good position. So to that extent, it's a little multifaceted, but not too many things to keep in mind. So you understand the business, understand the commercial objective, कि business को क्या चाहिए, what is their end game, work backwards, fit it into IP construct, and take a flexible approach. IP is never black or white. There's always a gray area. And you really want to be playing in that gray area to give maximum advantage to fulfill the commercial objective.
Yes, sir. Thanks.
Okay, fantastic. So Shreya, before I hand it back to you, thank you all so much. Okay, I really wanted to have an interactive session, and that's exactly what I've gotten. And I hope I've been able to answer some of your questions. Like I said, if there are more questions, doubts, if you guys want to have a chat on building a career in IP, more than happy to connect on LinkedIn, more than happy for you to drop me an email. Shreya has my email, and we can have a conversation after that. So thank you again so much for having me on a Saturday afternoon. Not the best thing to listen to a lawyer on a Saturday afternoon at 3 p.m., but really appreciate all of your time and effort to be here. Thank you.
Thank you so much, sir. We thoroughly enjoyed it. But before that, I would request Aishwarya to extend vote of thanks to you.
I'm humbled to take this opportunity today. And on behalf of the RGQuest team and the attendees, I would like to heartily thank Mr. Bharadwaj Jaishankar. So thank you so much, sir, for taking out the time out of your busy schedule to be a guest speaker at our webinar. And I'm certain that your wise words and experiences help our perspective, widen our perspective to a great extent in the best ways possible. So thank you so much again for gracing our webinar and invigorating our spirits. It's been a pleasure listening to you. Thank you.
Pleasure is all mine. Thank you for listening, and thank you for being such an amazing audience. I'm really hoping that this is a start of a journey where I can work a lot more with your law school and give back to students what I've got from my seniors. So thank you.